Okay, family test 7. This is going to be in 2 videos. I'm not going to finish it in 1 video. An appeal taken under Article 11 of the Family Court Act must be taken no later than 30 days after service by a...
Catch me flying through your wood in a drop top B. I'm in the pop top 3. And my pops got G's. So the watch got chili. And the rocks got
Appeal
free.
taken under Article 11 of the Family Court Act must be taken, and it's always 30 days unless there's mail involved. Then it's 35 days. That's all you got to remember. 35 days if there's mail involved. If there's no mail involved, 30 days. Just like regular civil.
And by like 6 in the morning, he forgot what he said.
So just remember, it's 30 days unless there's mail involved. There's something, it says something about mail, the answer is 35 days. Okay, so it's 30 days just like regular civil. Unless there's mail involved, then it's 35 days. Next one, numbers 2, 3, and 4 were true or false, and each had a slight difference in the question. So pay attention, follow along, because I'm only going to read the true one. And that was number 4. The other 2 were false. So listen carefully. The notice of permanency hearing, but not the permanency hearing report, shall be sent to a former foster parent in whose home the child previously resided for a continuous period of 12 months in foster care, unless the court, sua sponte, or a motion of any party dispenses with such notice on the basis that such notice would not be in the child's best interest. A former foster parent shall not a party to the proceeding. So what you're going to get out of that is that they get the notice of permanency hearing, but not the report. They shall have the right to be heard, but they are not, on the basis of such notice, a party to the proceeding. And that the court, sua sponte, or on motion of any party, can ask that that notice be dispensed with. And it's a continuous period of 12 months. I cannot emphasize that enough. Please know that it is a continuous period of 12 months while in foster care. Okay? Not like they stayed with them, at the parents' request. It has to be while they were in foster care. Next, a pre-adoptive parent or relative providing care to a child who is served with a notice of hearing and copy of sworn permanency report shall have the right to be heard, but shall not be a party to the proceeding. They shall have the right to be heard, but they are not, on the basis of such notice, a party to the proceeding. And it's a continuous period of 12 months. I cannot emphasize that enough. Please know that it is a continuous period of 12 months while in foster care, as it has to be while they were in foster care. Next, a pre-adoptive parent or relative providing care to a child who is served with a notice of hearing and copy of sworn permanency report shall have the right to be heard, but shall not be a party to the proceeding. So even though the pre-adoptive parent or relative providing care to the child, they get the report, but they're still not a party to the proceeding. They get the report, but they're not a party. So even though the pre-adoptive parent or relative providing care to the child, they get the report, but they're still not a party to the proceeding. They get the report, but they're not a party. It's like little tricky differences there, but you're going to get it. Again, just know that this is 7, be able to recognize that those 7 people from the other video get the permanency report, and then these other 2, the child if they're over 10, and the former foster parent that resided for 12 months, they only get the notice of permanency hearing. And then the 2 that have the right to be heard are the former foster parent and the pre-adoptive parent or relative providing care of the child. They're not parties, but they have the right to be heard. When service, true or false, number 6, this is true. When service of an order is made by the court, the time to take an appeal shall not commence unless there is an official notification in the record as to the date and matter of service in the order. And if you ever worked in family court or you've ever worked in IDP, you see at the bottom of those orders, there's like a box that it says you have to check the box saying that you mailed it, whom and when. And then that gets scanned to UCMS, and then that's the official notation in the record. That's something I could see them if they're thinking clearly, maybe asking, because it's something that a clerk might actually have to do. check the box. An official notation in the record as to the date and manner of service of the order. On the bottom of those orders, order mail, date, to who. That's the official notation that they're talking about. Okay, number 7. Okay, next, number 7. This is a time rule question, so one of my favorite. When an appellant is seeking relief to appeal as a poor person. Now, these are different rules than in civil. So in civil, the transcript has to be requested by the clerk. The clerk only gets 2 days to request it. And then the stenographer has to prepare it within 20 days. This says the transcript appealed from shall be requested within 10 days of determining the motion for poor person status. Such transcript shall be completed within 30 days from the date of the request. So, the bottom line is for number 7, it's asking only for time rules. You have to know that in family court, the time rules are 10 and 30. The time rules are 10 and 30. You request within 10, get it completed within 30. In civil, you request within 2 days, and it's got to be completed within 20 days. So that goes to show. Not sure in civil, guess 20 days. Next, number 8, 1039. An ACD, so an adjournment in contemplation of dismissal in an Article 10 case, shall not exceed, and the answer is D, 1 year plus any agreed upon extension. Next, an order suspending judgment in an Article 10 case may be for a period of C, 1 year plus 1 additional year extension. 1054, an order of disposition may release a child to a non-respondent parent or person who is a child's legal guardian at the time of the filing of the petition, which may be issued in conjunction with an order of supervision, order for services, or an order of protection. The period may be up to, again, 1 year plus an additional year extension. So 1 year plus 1 year extension for the suspended judgment and the order releasing the child to non-respondent parent. And ACD is 1 year plus whenever. Note that these dispositions generally require progress reports to be submitted by CPS every 90 days if the disposition was granted on consent of the parties and the child's attorney, unless the court decides it's not necessary.